And I've been with AgCountry for 14 years in this position, our succession and retirement planning department. Born and raised in Minnesota, and my wife and I have 4 kids in Glenwood. And my background, I'm an attorney by trade, but I've this role as a business consultant, as we'll get into today, we talk about a broader type of planning structure that ties in the financial, the tax, the legal, the communication pieces of the farm transition and the planning personal to each operation. So a little bit about me.
And with Bobbi.
Can you hear me? Okay. I'm Bobbi Sondreal. My main office is at Grand Forks. I grew up in the area here. My family farms near Hillsboro. My brother, sister, and brother-in-law operate that farm today. I've been with AgCountry for just over 2 years, and prior to that, I was a wealth management advisor for many years, and also did some agricultural lending. So, super grateful to have the opportunity to work in the planning piece and helping the farmers and ranchers in this important aspect of their business. A different way for me to be involved in agriculture since I'm not hands-on on the farm. So,
A little bit about our department. Russ Tweeten, so Bobbi, myself, and Russ Tweeten are the 3 consultants in our succession and retirement planning department, and we have 3 wonderful support people as well. What we do is we meet with farmers, producers, their families, and build plans specific to each individual needs, right? But each plan, it's pretty common to include the estate planning component, some type of transition retirement planning, depending on whether you have a next generation coming in or not, how to set that up, how to manage that. Entity planning is a big one, whether or not to set up a partnership or a corporation, LLC, that type of thing. Asset protection, really anything having to do with the farm estate business types of plans. We build plans for that. Another thing to know is it's an expansive approach. We're part of a team. So your team, your loan officer, your attorney, your tax professional, your financial advisor, your insurance professional, they're all intricate in this process. So we work together with them at your direction, building a plan that fits your needs. So little background on the
Sounds good.
department.
Thank you. I think back to just growing up and helping my grandpa on his farm and my dad on his farm as well. It seemed a lot simpler back then, and these days, the farmers have a lot of hats, a lot of, from CEO, CFO, to a mechanic, to agronomist, all kinds of things. And so it's always good to surround yourself with a good team. And so, again, appreciate you guys being here. Again, questions available online if you'd like to text in or raise your hand, and we'll get you a mic. But just kind of starting off here, Andy, over the last few years, we've had a lot of changes in taxes. And obviously, you guys aren't tax preparers, but you have estate tax and other things that you deal with. And so just kind of comment on, what has been the most recent changes, and what do we kind of need to know when it comes to the current estate tax and maybe some gifting limits or some things that we need to talk about there.
Sure. Well, the estate tax is, it's broken down into a couple different, well, first of all, there's a federal estate tax. And to start off, the estate tax is governed by an exemption. And think of an exemption as a cap or a ceiling. If you pass away and your taxable estate exceeds this exemption, anything above that gets taxed at for federal purposes, a rate of 40%. Mm-hmm. Now for 2020, that exemption is $11,580,000 per person. That's part of a relatively recent tax change from 2017, where before that exemption was $5 million, roughly $5.5 million per person. So with that tax rule, it has more than doubled. So a husband and wife can collectively combine their $11,580,000, and if they die, and that's the key, it's in the year of death, whatever that exemption is, if your taxable estate exceeds that, then and it passes to anyone other than a surviving spouse, then there's a tax of 40%. Now, the history with that, you could call it kind of a moving a wave, or it goes up and down. I've said a few years ago it was at 5.5 million. Years past, it was at 3.5 million, 2 million. It is set under this law to expire in 2025 and go back to what it was before. We all know with legislation and politics and such, if they want to change it prior to that, it could happen. So it's something that we need to be ever mindful of and make sure that it's a key piece of the planning.
Now, is that the same at state and federal level, or is there a difference, between Minnesota and North Dakota on the state?
So Minnesota has its own set of estate tax rules. They're one of the few states that differ from the federal limits. So Minnesota has a limit of $3 million per person, and you can't port that over to your spouse like you can on the federal level. So it becomes a little bit more challenging as we're trying to plan. Additionally, farmers can qualify for an additional exemption of $2 million if you meet certain requirements as your heirs keep farming it, the assets transfer to a qualified heir for 3 years following that. So again, we have to be a little more careful when we're planning in Minnesota because we're working with two separate sets of rules.
Good point. Minnesota does have its own state estate tax. North Dakota does not. South Dakota does not. There's about a handful of states in the country that do. So.
Okay. But all to be going up seems to be, they've been raising them. Even at the state tax, has that been going up recently as well in Minnesota?
So Minnesota was at 1 million, and over the course of a couple of years, it's gone up to that 3 million, but it's kind of capped out there. I don't see any legislation that would increase that, right, Andy?
Yeah, I'd agree. Bobbi, something you said too, the ability to port your exemptions, that's a good thing to bring the distinction. So for the federal estate exemption, I said husband and wife can combine their amounts. That's called portability, meaning when the first spouse passes and the assets pass to the surviving spouse, they can also, any unused exemption at that first spouse's passing can be ported and used at the second spouse's death to effectively use both exemptions. Now, what does that mean? Let's compare it to Minnesota. Minnesota says that when you pass away and assets pass directly to your surviving spouse, and he or she owns them individually, there is no estate tax exemption. It's an unlimited marital exemption or deduction. However, there's a trap there. That $3 million that Bobbi was talking about, if it goes directly to the surviving spouse, that then, because there's no tax and it's an unlimited exemption, when the surviving spouse passes, they're not able to use both his and her $3 million exemptions. So we need to have it critical in your plan, if you're a Minnesota resident, to say that when the first spouse passes, there be some specific language in there that he or she is able to do what's called a disclaimer and bypass themselves if it's necessary for estate tax purposes. There's extra steps that the federal government no longer requires, but Minnesota does. So.
And it'd probably be good to note that a lot of the older documents that were written, this probably wasn't an issue. So it's a good time to review them. Make sure you have the proper language, especially for Minnesota residents.
Definitely.
Without getting into too much of the details, I get the privilege of traveling with you guys all winter long when we host our farmer meetings, but there's also something else in Minnesota that, isn't there a transition to a family member or something that we even get another, not an exemption, but an accept, or
Yep.
Can you talk a little bit on that?
Yeah, so I touched on that, and that is that additional $2 million, and farmers can qualify that. It's called a qualified small business exemption. So essentially, if we properly plan, we could capture $5 million for each of you. So they're doing a little bit of a favor for us. Minnesota is not always helpful on the tax side of things, but at least that does give us a little more leeway to plan with.
Now, sounds to me like you need to have a plan, especially in Minnesota. There's a lot of things to make sure we have that right. But part of that plan, sometimes we see possibly of gifting of assets. Now, is that this can we just unlimitedly gift? Can we just give everybody all of our estates and we don't have to worry about it and it's safe? Or what's some rules around the gifting?
Sure. So we often use gifting in our transition plan, and that's not to have you just give away all of your life's work. I understand that you've worked hard for it. However, gifting is the most tax efficient. So we try to find ways that we can use that if it works in your plan. The annual gift exemption amount is $15,000. So per person, you can give $15,000 to any person in 1 year and not tell the IRS about it. So $30,000 for a married couple. If you do go over that amount, and that could be assets or cash, we count those as gifting, or even a discount on selling them the land. That discount could be considered a gift. So we have to be careful about what we are gifting, but if we go over that $15,000, we need to report it to the IRS on a gift tax return. And what that does is that $11,580,000 per person we talked about earlier, we start tapping into that. You don't get two, so you can either use that during your lifetime, or it's available to you at death. So if I gift $1 million today, I can take my $15,000 off, and the remaining I have to take off my $11,580,000. So you start to eat that up. Because the limits are so big right now, we've been utilizing gifting quite a bit, but there may be a catch if the tax law changes, and it is set, like Andy said, to sunset in 2025. So if they do nothing, it's going to change regardless. So maybe you can touch on what happens then, Andy.
Well, there's nothing specific, but there's been information put out there to say what happens when the exemption goes from 23 million down for a married couple down to 11, and people have made significant gifts. Because like what Bobbi said, when you make a gift in any given year that exceeds that annual allowance, which is for a married couple $30,000 to one person, it comes off of how much you can exempt. So if you gift it today in 2020, it comes off of the 23.5 million. If you pass away when it's in that year, that's fine. But then what happens when that exemption goes from 23 million to 11, or whatever it will sunset back to be? There's been discussions on that as far as being able to, because you did the gift when the rules are as they are now, that you can't be penalized if they later come back and lower that. Gifting's a really good strategy to look at. You know, when we talk about gifting is, it's just like it sounds. You are transferring ownership with no payment, right? Now, why do we focus a lot on that? And Bobbi hit it. It's a real tax. It can be a good strategy for income tax purposes. A few common examples that we look at is if we have a farm transition from one generation to the next, and we have a line of machinery, for example. Machinery and equipment, when you sell it, to the extent you've depreciated it, you have to do what's called depreciation recapture. So if you've got a line of equipment that's $1 million line of equipment and you've depreciated it fully, so its taxable basis is little to nothing, when you sell it, that $1 million that, in my example, that you get, that's all taxed as ordinary income because it's this depreciation recapture. Now that's true as well whether you do it all at once or you have what's called an installment sale. So you have that next generation, he or she wants to buy that equipment and say, okay, we're going to pay you over the next 20 years. If you have it structured as a sale, that depreciation recapture gets all in 1 year, all in that first year. So that's a big hit for, preserving as much of the assets as possible. So we look at other mechanisms such as gifting, and then other methods of repayment, say in the form of increased cash rents or labor, that type of stuff, to achieve the same result, but do it in a tax, to help manage the taxes.
Great, well, I appreciate that. And there's a lot of, obviously, planning to get that stuff ready, but, what happens if you pass away and you don't have a will? What kind of are the steps, and where do we go from with that?
Well, if you don't have a will, the state has a plan for you. So that may or may not be in line with what you want. So each state has its own set of intestacy law, meaning you pass away without a will, and will divvy out your assets as they see fit. That's not always what we want, especially if we're transitioning. We want to make sure it's not just an asset transfer. We're actually trying to transfer a successful business and make sure that it can continue to be successful. So making sure that our wishes are written down and that they're consistent with our transition plan. So if you're transitioning to the next generation, I would say every 3 to 5 years you need to be reviewing that estate plan to make sure it's still in line, accomplishing what you would accomplish in your transition if you were here to do it. Because if you're not, we're going to look to that document. And if it's completely different than what we have going on, it might just blow up the whole plan. If you have retired or you're not transitioning to the next generation, there isn't someone to take over, I'd say reviewing that document every 5 to 7 years would be reasonable. That doesn't mean you always have to update it, but take it out and look at it. As well as any, deaths or family situations change, it's a good time to take it out and review it, and we can help you do that as well.
Sounds like even with tax law changes, we need to revisit it every 5 years, even if the family status hasn't changed.
Absolutely.
There could be some issues there with just the way the tax law can change. So, and I'm sure you guys deal with a lot of families that, with multiple children, maybe one's on the farm, maybe one's off the farm. How do you divide up an estate when, somebody's gone off to the cities and is working, and then you got the one person who stayed home and is the farming child? How do you work with, an estate like that if somebody passes?
That's a good question, Rob. That is the goal of every estate plan that we do, to try and figure out this term. You might have heard it, the fair and equitable distribution of assets. And that's particularly difficult when we have, like Rob explained, a farming child and non-farming children, right? So when we're talking about this, it's putting together an estate plan. So having it in your will or in your trust to say, when I die, here's what happens to the assets. And like Rob said, if we have a farming child that has been working into the operation and continuing to keep it going, and a key question in that fair and equitable distribution is, how do you get the assets to that child, or what is your goal with that, and also provide a fair inheritance to the non-farming children too, right? How you do that is, there's no check the box here, do this, do this, do this. There's options, and it's working with the people to say, okay, what is your definition of fair and equitable? How do we look at doing that? And then giving different ways to accomplish it.
Sure. Definitely encourage probably open and honest conversations with all involved, and
yes,
make sure that they're aware of what your wants are.
That touches on a real important topic too, the importance of communication. That sounds cliche, but it's so critical. Communicating what you want to do with your plan. Not only communicating with your kids, but communicating with each other, right? Husband and wife, a lot of times that conversation is a difficult one to have, or a lot of times there's different opinions there, right?
Mm-hmm. Mm-hmm. Yeah, so the question is, what's the difference between a transfer on death deed versus a life estate remainder transfer of ownership to the individual? So a transfer on death deed, I like to consider it kind of like a beneficiary designation on a bank account or an IRA. It just sits out there, and at death, then we know where that asset goes. The benefit here is that it doesn't have to go through probate, because there's already a set of instructions out there. We know who the owner is at death. However, it's still fully owned by the grantor, the person that owns it in that case. So it's still one of their assets. So if we're looking for asset protection from nursing home, it's still a countable asset as available to pay for care. So sometimes people want to get those out. We use those quite a bit to try to help with the plan, especially if you have, let's say, property in multiple states. So you have a home in Arizona, get a transfer on death, they call it a beneficiary deed in Arizona, so that you don't have to have probate in multiple states. So it already has a plan there. The life estate deed, you actually are transferring ownership on the date of that deed. That remainder ownership is part of that person's asset base. So those are kind of the differences there. Andy, would you add anything?
Sure. A couple key differences there is a transfer on death deed is revocable, just to make that distinction. Its main tool is, like Bobbi said, is to avoid probate. Now, what's probate? We can get into a whole discussion on that. Probate is when a person dies and they don't have a preset path for an asset, such as a transfer on death deed. Then it goes through this court proceeding before the asset can transfer legally from the deceased person to whomever is inheriting it, right? Now, probate in itself isn't the worst thing in the world, but oftentimes it's kind of vilified, or you hear tough stories about it. It does take time, and it is a court proceeding, so there's a lot of pieces to it that need to be worked through. A transfer on death deed is a tool to avoid probate. So you're setting it up, like Bobbi said, to when I die, this automatically, or you have to file a death certificate and do some filing, but it goes to whomever you put on that transfer on death deed. Here's who it transfers to. A life estate is irrevocable, and that's considered, that's something to really think through. Like Bobbi said, once you give away that control, the what-ifs in that recipient's life are now something you're going to have to deal with it. For example, I had a scenario where mom and dad gave a future interest, so the remainder interest in land, to their kids, one of their children, and then that child unexpectedly passed away. That asset, like Bobbi said, that asset was his asset in his estate. So now that passed to his surviving spouse. And that wasn't nothing against that surviving spouse, but that wasn't mom and dad's intent. So that's a good example of how it's irrevocable, and they were there to witness that, not only losing their son, but also now they have this asset they'd like to make a change on, but can't. It's stuck. It is an irrevocable deal. So.
Good point.
I'm sure some of those conversations are hard to have,
Yeah.
Especially with the family dynamics. You just never know, and you guys are obviously part of a lot of those conversations, and see a lot of different things. But and even with that, I mean, we have talk about these plans and putting these plans, whether it's for the estate or the transition, and I think you both actually said time is your friend, and it takes time to get through these. And so, Bobbi, just kind of start with you. Is how long does it take to transition a farm to the next generation? At what point do I start? When do I start that plan?
Sure. Agree 100%, time is your friend. If you're transitioning, you have someone coming in, I would say 5 to 7 years, start that conversation. It's never too early. Just because you have that conversation doesn't mean the next day you're out and we're move on over, younger generation is in. It takes time to get the younger generation acquainted with your business. It takes time to transfer assets. It takes time to get out tax efficiently. If you're retiring, don't have another generation coming in, I would say 3 years at a minimum, and of course we can do it faster. It's just going to maybe sting a little more to Uncle Sam. You'll be sending some tax dollars in, but 3 years will allow us to get you out gradually and use some planning structures there. The more time, the more flexible you can be. So those are kind of not hard and fast rules, but really good timeline, I guess. I meet with people, and we know we're not going to start to do anything for a couple of years, but I can almost guarantee you that younger generation is itching just to know that you're even thinking about it. That doesn't mean that it's going to happen overnight, but it's easy for you guys to plant the crop, harvest the crop, and everything like that this is easy to put off. And so now all of a sudden, older generation, I had a gentleman, he was 92 before he even started. I don't even know that he transitioned. He just passed away and it had to transition. But think about the people who are now coming into that at age 70. they're ready to transition, and they waited for dad to never do anything. So don't get yourself in that situation.
Sounds good. And again, questions from the audience, and again, I'm following a few here online. With that, maybe, just kind of each of you touch kind of base on what you see. What are the golden nuggets you need to take from a message from you guys, as far as what do I need to take back to my farm and need to relay the message to my partners, my spouse, my kids? What would you take back from a discussion with you? And we'll start with you, Andy.
Sure. Well, that's a good, there's a lot of ways to answer that, a lot of golden nuggets, but I'm biased, of course, being in this business. A few things that I really try to hit home is the importance of having, regardless of the time in life, the importance of having an updated estate plan. And that is particularly important when we have a farm transition as a part of it, right? So if we have a farming and non-farming children, and we're working through a transition plan, mom and dad are alive and well, all of a sudden there's an untimely passing. Does that estate plan jive with the transition plan, right? Or are we going to go backwards? Everything would be going just fine, and then if the will is 30 years old and it says, oh, everything gets divided equally between all of the kids, and there's no specific route to say, here's how the assets transfer, or here's how that farming child is able to continue with the operation, building that fair and equitable distribution pattern, that's the will, that's the plan. That will put a transition plan, it'll stop it. So we have to make sure that estate plan is up to date and that it's living right along with you. Also with that, part of a complete estate plan, we have a will or a trust, and we can talk about the differences between those. But in addition to that, we want to make sure we have what's called a durable power of attorney and a healthcare directive. And these deal with incapacity. So if I have a sudden illness, or I am all of a sudden unable to act deal with my financial matters or make decisions for healthcare, what these documents do is it allows for me to legally appoint a representative, an agent, to step in and make those decisions for me. Its main purpose is to make sure that the person or the people I want to do that are listed, and also to make sure that if something were to happen, especially suddenly, my family wouldn't have to be stuck having to get some type of guardianship or conservatorship appointed through a court proceeding because there's no legal document. That's one nugget. What do you think of some other ones?
I always go back to communication. Honestly, I think it will either make or break your plan. Being able to communicate, have those conversations, they aren't always easy, but we can help. Get everyone in the same room, get everyone on the same page. You've built what you have. None of your kids are entitled to any of it. So do what you want with it, but maybe communicate with them so they're not surprised. We all might have our ideas of what mom and dad want, and if we have our assumptions somehow become reality in our head, and that's when we start to have confrontation. So communication, I'd say, is a huge piece of the plan.
And I think, as you guys mentioned earlier, the state has a plan. Regardless, if we do nothing, there's at least the state itself has a plan. And if nothing else, we can always make it our children's problem or our grandchildren's problem.
Yeah.
So to make that transition smooth, I assume that's the biggest key, is why I like the communication, and that's important in all aspects of farming these days. So with just a couple or more minutes left here, if you got a last minute question, I think we'd open that up. But I know both of you guys travel across AgCountry's territory through all of the branches. And is there any, I think Russ, you mentioned it as well, how do they get a hold of you guys, or how would they do something to get that rolling?
Great question. So how we operate 99% of the time is through face-to-face meetings, right, or impersonal meetings. And what I have here is a packet of information that if you talk to your loan officer, your AgCountry branch, and they can put you in touch with us, and then we'd schedule an appointment, right? And that's how we would get started, that one-on-one conversation. And then we send you out a packet, and in this packet is some information, but in here is a questionnaire that that covers all sorts of things. It talks about what is your current estate plan? What are your goals with retirement? What are your goals with farm transition? It starts the process. It starts having you start thinking about what are your goals. And then we set an appointment at the branch or wherever you'd like to meet. And then we just get started with the conversation. Kind of like I said earlier, every plan is unique, and that's how we treat it. So we're specific to what your goals are.
And just to touch on that, I'm up in northern Minnesota and the northern part of North Dakota. Andy's down in southern Minnesota, and then Russ is kind of in the middle there.
Sure.
So we're all here to help in the various offices where you do business.
With that, a big thank you for those of you who joined us here at Big Iron and in the Red River Farm Network Issues and Events Center today. And those of you online, appreciate you watching virtually as well. And we hope you all have a great day and enjoy your time here at Big Iron. Thank you.
Thank you.
There's no way to count the number of sandwiches you've packed over the years. Hard to imagine this day would come. Yeah, there's still the same fields, the same roads, the same hard work. But now they're in someone else's hands. And you couldn't be more proud of who you're handing the farm to. No matter what the future holds, AgCountry is here to help you play.